This lecture, we're going to continue and talk about the implied terms on page 83 actually. The implied terms of the contract of goods to presume the freedom of the parties. Some terms are implied into the contract, and these are terms of conditions and warranties. Note that they could be excluded by the parties. Implied terms as to warranties. A. An implied warranty that the hire shall have and enjoy quiet possession of the goods. The general rule is that the owner must ensure that they remains in peaceful and undisturbed possession. Not that interference from an interested third party without constitute a disturbance. So they are well kept by him. B. An implied warranty that the goods shall be free from any charge or encumbrance in favor of a third party at the time when the property is to pass. A charge or encumbrance in favor of a third party on goods which are subject of a hire purchase agreement, of course, agreed upon, would remain perfectly good at the time of the hire, because the ownership only passes when the hirer elects to exercise the option to purchase. Continue. We are going to talk about the conditions included in the contracts actually, or the contract between buyers and sellers. Conditions: there are certain implied conditions under the law. Implied conditions under the law. So they are protected by the law at this point. First, title. An implied condition on the part of the owner that he shall have a right to sell the goods at the time when the property is to pass. This provision is aimed at assuring the buyer that the seller is an absolute owner of the goods, without any cheating or any vagueness in that sense. In addition, the right to sell arises at the time of the delivery of the hired goods and not when the agreement was signed. This is the title. Merchantable or mercantile quality. In hire purchase agreement, there is an implied condition actually that the goods are of mercantile quality. However, no such condition will be implied where the hirer has examined the goods or a sample of them, and the examination ought to have revealed the defects of which the owner could not reasonably have been aware at the time when the agreement was made. The third condition, fitness for purpose. Fitness for purpose, where the hire expressly or by implication makes known the particular purpose for which the goods are required. An implied condition that the goods shall be reasonably fit for the purchase, and not otherwise any cheating or anything that will breach the contract. Sale by description. Goods sold by description must correspond to the description given. Note that the plaintiff can only recover if the goods correspond with the description, provides that goods sold must be of mercantile quality. that is, the goods should be suitable for any purpose for which of the goods are normally used. But the buyer examines the goods and do not complain. He is bound and cannot complain at a later date. So he has to get the goods without any complaint. Where it was held that where a party to a contract to sell of goods satisfies himself of an examination of goods, he cannot say that the goods are defective or bad. Sale by sample. Under sale by sample, the bulk must correspond with the sample itself and not otherwise. Correspond with the sample in quality, and the buyer shall have opportunity to compare the bulk with the sample itself to be correspondent with each other. Transfer of property by non-owner. Transfer of property by non-owner. It is the general rule that good title would not pass unless the buyer gets a good title free from any encumbrance by buyer from the owner of his authorized agent. But there are circumstances in which the law will deem a proper transfer when there is a transfer by a person who has either no property or whose rights are defective. Dispose of goods. The general rule in this sense is built on the legal principle of the Latin maxim nemo date quod non habeat, which means that no one can give what he or she does not have. Again, it means that no one can give what he or she does not have, because he doesn't have it. How he will transfer it or get it to another person? The purpose of this rule is to protect the interest of property owners. So the owner himself has to transfer the property and the title himself and by himself to the other when the contract of sale is taking place. Exceptions. There are some exceptions in the law and according the law actually. Sale under agency. Sale under agency. So we have to have an agent, and we talked about earlier. The main exception under this head is the sale by an agent, and it states that an innocent buyer would acquire a good title where the seller sells under the authority of consent of the owner. So he is instead of the owner actually as an agent, and he has agency. In this instance, it means that the sale by an agent without actual authority will give the purchaser a good title if the sale is within the agent's apparent or usual authority. So if he in his power or authority, he can really transfer the property without any problems and without any raising any dilemmas or what else. Estipend. The owner of goods represents that another is his agent or allows a person to represent himself as his agent, although no such agency exists in fact. He, the owner himself, will be stopped from denying the existence of his agent authority to act on his behalf in relation to the goods.